proceeds, Your Lordships. Well, I'm appearing for the respondent.
Yes. Yes. So, Your Lordships have raised a query on the last regarding whether there are any authorities on the point in non-relied upon documents have to be furnished before the prosecution and adjudication be taken forward. I'll answer that point, but before that, because I just want to do
prayer, you want the documents to be written.
Yes, and that's
documents which are not considered in the departmental.
So in documents नहीं है मेरे जो documents इनके पास हैं जो ये rely नहीं कर रहे हैं अपने शोकॉज नोटिस के फेवर में. That is the only prayer. That is the only prayer. Just two prayers. Just to add. Second is also the point which is a secondary to that. That आपने मेरे against in the showcase notice you have relied upon state takes number of people.
Counsel, can you speak in English, please? That's a thing.
Yes, I will. It's sorry. So in the showcase notice, there are also 20, 25, 30 X number of people whose statements you are relying upon me, relying against me in the showcase notice. Those are witnesses in support of the showcase notice. It is also a right, as much as getting documents, that I have a right to cross-examine it. And all those witnesses, and once I'll take assistance of judgments of the expert and also several other decisions. But just to bring to your lordships, one very, very important point. Because with respect to the same matter, there is a alternate division bench decision by this honorable with respect to the same matter. Just want to bring to your lordship's notice this particular judgment, and I want that if you want to this
even we have dismissed.
No, this is one we were allowed earlier. This was the one which was allowed. It was allowed by an earlier bench where my lords were not hearing the matter. It was led by Honorable Justice Lucia Sir, where the petitions were allowed because they were not opening by authority. So there are pertinent observations which I just want to place seek assistance for. So if my lords will just have the rules, the central excise rules, and by the lords, I want to just show time of issue why my case is made out. If my lords will just have the central excise rules. So one of the courtmaster giving a copy to there. Now the central excise rules essentially say that my lords, whatever I will manufacture, it's an undisputed position. Whatever I will manufacture and I will take out of my factory for sale, excise will be levied on it. There is an undisputed position. Now,
Lord, sorry for the interjection.
No, please go, Venkataraman.
One minute, Mr. Counsel, 1 minute. Mr. Counsel, one minute, Mr. Counsel. Lord, I may be permitted. Lord, I think my friend has to answer one question and only one question in this writ petition. With a complete abuse of process, 7th time they are coming for a writ petition, 7th time in 4 years. And let him say his case is non-related documents are not given to him. We have said, please come and take it, number one. He is asking for 11, 12 and 13, which were lost documents, which we have filed an FIR and we have given him scanned copies. So we are ready to give him from 2022 itself. For the last 2 years,
Originals have been lost.
Now, except, I'll explain it. Well, this is the only point in this repetition. We don't have to
ready to return the documents.
Yes, well, I'll tell you, out of 14 documents seized, 11 documents are handed over in originals. We are given to him. We are ready to give from the last 2.5 years. 3 documents, we have filed an FIR as lost, and we have given him scanned copies. And these are not relied. They are non-relied documents. We are not relying on them at all. This showcase has nothing to do with documents. Number 2. Number 3, 1 minute, Mr. Counsel. Most important is this. What are these 3 documents? 11, 12 and 13. One is an income tax return, which they have. Another is trade notices issued by the Central Excise or the GST department. And third is the statutory form factory registration compliance. These are all not slips or anything that we have seized. These are all the 3 are statutory records. So, one ballot, because it's a very simple case. Give me 5 minutes. Let me answer.
Please let me first open my case. Then you respond to it.
Let my friend answer only that question. It's a clear abuse of process. It's a complete process. Let my friend answer. Lord, his question I am answering. If you start implementing central excise law for 3 days, If you start central excise law for 3 days, it will never end. But absolute abuse. Lord, please see 3 things. Let my friend
this is unbelievable. He's responding to the
now my friend is asking your lordship to go into central excise for 2 hours. It's not required. Let him argue. This is all the case. This
No,
is
Mr.
not,
Venkataraman, not
not 11 records we are ready to give in original. 11 records we give it in original. 3 records we have given him scanned copies, and these 3 records are statutory registers. They are not private records at all. And Lord, we have got a letter from the forensic department confirming that these records are the records as seized. We have got the FIR registered, and my lord, we have given him the certificates issued required under the law in terms of the
Just
Special Act.
dispose the petition with the direction to hand over the documents which are not the show cause notice.
Yes.
That's all.
That's all. So the proceedings can go.
That's my doubt.
Because
Precisely, this all.
documents you have seized, you must have made a list of that
Yes,
at the time of seizure.
correct, correct. Can I
You
show
can compare with the show cause notice documents relied in the show cause notice and which are not relied in, please return them.
We are gladly returning it. Happily
Well,
returning it.
there-
We have no hesitation in returning it. We have no problem. This is all the case, my lord. Why are we now debating? This is all the
No,
case.
let me.
See, we cannot go into the actual aspect which document has been seized, has been returned. We cannot say about that. We can only say those documents which are not relied
Yes.
may be returned.
Yes, absolutely.
In which there are two sets. There are two sets. There are two sets of it. 11 documents we have originals. 3 documents we have scanned. And these 3 documents we can give only scanned because we have filed an FIR. And these are not his private records. These are statutory registers. I'm not going to do it. And we are not relying on them. We are not relying. Now my friend is now scuttling the entire 2,000 crore demand. Blood, it's a 2,000 crore proposal. He's trying
We
to
are not
scuttle it.
saying that the time may go on.
It's
Yeah.
We cannot say that.
Yes.
Yeah.
And
Asking for-
completely he's trying to drag the whole proceedings in one way. And this is the 7th attempt. This is not the first attempt. Seventh time, my lord.
Absolutely.
Please
It is
dismiss
a
it.
lot of dismiss the challenge to send that because that judgment gave Alex with this. There's no problem beyond it. Now, the lead finds it just to, because he's showing on Canada. My lord will see 2 things. We ask them what we will switch. It should not take more than 2 months. It will not take more than 2 months.
No, we are waiting to supply the document.
It is well beyond the light upon documents because that is the law. That is 67 to also mandate.
Say that certain documents have been lost.
So as far as that is concerned, now let's just want to first we deal with it on the statutory provision. I'm just reading section 67(3) of the GST Act. Just one second, only one provision. I will read a second provision. Since my lord is talking about the conduct, let me show their conduct as well. 67(3) subsection 3. Malak Sahib. First, when they do a search, this is under section 67(1) and 2, and whatever they are not relying upon, that is dealt with under section 67 subsection 3. The documents, books or things referred to in subsection 2 or any other documents, books or things produced by a taxable person or any other person which have not been relied upon for the issue of notice under this act or the rules made thereunder shall be returned to the person within a period of not exceeding 30 days. So everything that you are not relying upon will return the document to me within 30 days. Now I wrote to them in July as per list,
They will return you.
Yeah, we are ready. We are ready. For 2.5 years, we are ready.
My lord will see, I wrote to them on 20th of July 2020.
There may be delay, there is a delay.
फाइलिंग के बाद हुआ है इस रिट पिटीशन की फाइलिंग के बाद हमको ईमेल्स भेजे आपके डॉक्यूमेंट्स
दे दिया
और इसमें से 4 डॉक्यूमेंट्स which my direct friend is trying to find out that it is harmless and those documents have no bearing. Let me just point out 4 documents also. So those 4 documents,
documents having bearing or no bearing,
yes,
they have to be returned
absolutely.
if they are not relied in the show.
Absolutely.
They are ready. They are ready.
Here, well, 1 minute. I'll add one more information. Which made the code. My friend refused to take it. He have emailed all the documents.
Venkataraman
Refused to take it. We have also emailed.
मैटर नहीं है कि जिसका
Understand? Only 2 points are there. Only 2 points are there. My lord have very clearly crystallized those points, and my lord will come to the relief clause. Just come to the relief clause. I'm grateful to my lords because lords therefore my lord will do exactly what I want. Page number 19 of my writ petition. I want only the things where my originals to be returned, which they are not returned upon. And second thing is given a right of cross-examining the witnesses. That's the law. You can't prosecute.
Lord, we are ready to give. He should apply. Lord, I'm so sorry. Lord, today is the case. Lord, whether cross-examination, how to fix.
So like, not just let don't apply. For 2 years.
Let me save your lordship's time. You have a lot of work to do. Not cross-examination, personal hearing. This is adjudicating authority.
Not be
Why are
important.
they converting a constitutional court into an office?
Let's not do this. Let's not try and argue against each other over a screen, please. Let me address the problem. Address the problem. Humble request. Let's not do this. I'm very sorry to interrupt, but please love it, like yourself. So let's, if you can see page number 19, my release which I saw from the Hon'ble Court. I am very grateful to watch my dispose of the
Entire prayer is
yes, there
it's on the documents.
cross examine. What should we see? My lords will see.
Not cross-examination, let him apply to the adjudicating authority. He will decide why is this court being converted into a tax office.
We are not directly.
will see Roman
That is a procedure to be conducted.
Followed with the adjudicating authority.
Notice is being passed this court by the index court, and I refer to those judgments where cross-examination was not permitted. I've been asking them for both the things, return my document and
Without even asking him, how can we permit it? Without even asking it to us.
Roman 4, issue a writ order of direction in the nature of so and so, directing the respondents to allow the petitioner to cross-examine the witnesses whose evidence has been relied upon in the short of against me. I'm just taking assessment of judgments and not see judgments.
Cross examination to actually before to adjudicating authority.
Yes.
Correct.
ये पर्सनल हियरिंग के लिए मुझे जस्टिस भाई को बुला रहे हैं उससे पहले मुझे क्रॉस एग्जामिन का राइट नहीं देंगे तो हाउ विल आई डू इट हाउ विल आई प्रोसिक्यूट द फाइनल हियरिंग I'll show them. I'll show them in my email reply. Very important questions on an actions.
Let him show where he has applied and where he has rejected.
Let me get back to that 22, page number 675. I was going to have a look at it. So after all these three things from 22.
Page number?
Page number 675. I love it when it's trying to broaden the point.
Where have you rejected?
No, yes, sir. Let's show you. But we are cooperating, we are saying with these two things, we will prosecute. We will not apply management see the two things. You see, in 2022, page number 675.
22 के बाद तो स्टे चल रहा था ना आपका 23 में फाइल
सब हमने डॉक्यूमेंट्स मांग रहे हैं वो दे नहीं रहे और आप पिटिशन फाइल हुई तो डॉक्यूमेंट्स दे दिया प्लस एग्जाम नहीं देंगे So I just want to place value on these three decisions of the apex court, nothing else. Just want to show the law to your hardships. But let's just look at the law and it matters. Would be kind enough to accept then probably was I'm talking to protect the directions of such issues. Now this is compilation my lords will see now as far as original documents is concerned, my lords will see our judgment is of the apex court and what is that?
Suppose some documents have been lost.
Yes.
Then what will happen?
Then I'll just show you an option from here. As far as these four files is concerned, जो फाइल उन्होंने मुझे दी है, that they are giving me, they say in their seizure memo, when they come and take it from my office, they say that it is a file of 21 pages. Now when they give me a scanned copy, which is scanned in May 2024, पहले ये कह रहे थे हमने पहले की स्कैन कर रखी है. 2024 की स्कैन है, which is showing to the property of the file. It is a 20 by 20 document. But some of the files, some of the papers scanned it and given it to me. Is that permissible? That's what I want to show to the election, but my government is not allowing me to do that. I'm making it on the law. So what's now? Let's pause on the judgment on the point regarding return of original documents. My lords will see the judgment of this court at page number 3. So that will take systems case. My lords will see page number 5. Number 5 and page number 4 of this judgment. Once it is shown to the department or the department sees that the documents are not required by the department and the department will consider the opinion that it is not relying upon the documents, it is duty bound to return the reports. They have no authority either under the law or under the circulars to sit tight over the books of record and refuse to return the same. The department has no authority under the law to keep the record with it. The respondents are directed to return the complete record except on which they are placing reliance to the petition on even so and so. Now, not only this on the report, but the division bench of the last writer and then the Gujarat. Next page, page number 5. You know, like next page, there's a Union of India. I will refer to only one paragraph. At page number 9, paragraph number 27. That one pays to see as to why the documents which were not relied upon were not returned to the petitioners. some of the non-relied upon documents appears to have been given subsequent to the orders passed by so-and-so, as can be seen from the record. In this state of affairs, it will be appropriate to intercept the order of the second respondent as part and to direct him to make available copy of the so-and-so also. So मैंने वो तकलीफ में directed कि आप photo notices and documents जो है वो उसकी कॉपी दो, जो non-relied upon है, return the original to the person. Now this is followed by another decision of the Allahabad High Court, which relied upon the Apex Court's decision in the case of Iron Private Limited. And specifically refer the options kindly kind attention to number 7. Number 7, paragraph number 8. Page number 12. In view of the above legal position, this court is also of the group ready to yes return it. So now the point is with regard to cross-examination. My last will come to page number 17 of this compilation only. Whether cross-examination also of the relied upon witnesses is a principle, is a point which is very, very important and goes to the root of the have you asking for these two things only?
Now the proceedings are again started.
Not at all started. He has not asked, I have not denied.
It's about hearing. That's why I hint there not just
Make a fresh application. 22 application.
Management see that cross-examination one and then this week.
Now that is true. They have to give the opportunity. There is no doubt.
So now
Then the finding another application, annexing the earlier application with that. Yes, they will grant you the opportunity.
In just a couple of days back, please extend the date. You are missing the matter and you are taking it out for order. So I'm grateful not to disposed of the both the connections are there. So,
May I only suggest, my lord, two suggestions to your lordships for kindly factoring it. One, my lord, please see only one document in our set, my lord, in his set, page 786, page 786. This is an incident, yeah, this is 12, it is 2 years old, 12/8/2022, wherein we have clearly conveyed our interest to give him all the non-relied documents and said that 11, 12 and 13 is not available. We will therefore give you scanned copies. So your lordship may say, we have already given scanned copies of all the documents, not relied. But we don't want it because we are not relying at all in the show cause notice. So let it be with him. It's a wastage of baggage in our office. So all the documents has already been returned through a scanned method. But today, let him come. He is refusing to come for the past 2.5 years. We are ready to hand over all the originals except 11, 12 and 13. And please for a minute see what is 11, 12 and 13 in the same set. Lord, please come to page in our counter, please come to page 187. For a flavor, what these documents are. These are not some private chits or some incriminating documents, not at all. They're all statutory records. Please see the record. 187 is the income tax. This is this income tax statutory return. So the copy will be there.
All these things, sponsor document, you please supply them according to the list.
No. What is trying to spin the wheel is, let me put a problem. He will again come. He will say, 11, 12 and 13, you are giving me scan and not original. Therefore, you should not proceed. Watch the show cause notice. Don't proceed is this case. He's stalling the whole proceedings. So I want to show just 2 minutes plot. 11 is nothing but income tax return. Then please come to 12. That is at page 196. These are all statutory.
You must have mentioned the nature of the document, whether it is photocopy or whether it is original. So as per the list, whatever is the document you have to supply.
We are ready. Just give me 2 minutes. We are ready to give originals, whatever originals we have, and whatever we don't have originals, which we have filed. I'll just show only 2 documents. Just 2 minutes. So file 12 is nothing but trade notices. Now file 13 is at 238. This is nothing but a factory compliance record under the Factories Act. Now please see only 2 documents. Please see 788 of my friend's paper book, my petitioner's paper book. This is the FIR we have filed. And please come to page 792. 792. Well, please see the effort we have taken. One more record, only one document I'll show, and with that, we'll wind up. Only 2 more minutes is required from your lordship. So we have filed an FIR saying that these 3 documents are lost at 792. And please come to the last record just to prove, because we are before Constitutional Court. I need not have said this to my friend, but I have to prove it to your lordship. 7, please come to our compilation 139. We have obtained a forensic report from the laboratory confirming the seized documents, and these documents have not been tampered with at all. Even though they are statutory, not related. We have got that certificate also from the government. Please come to their own counter, our counter, page 139. Only one, Ministry of Home Affairs, and only one document. 139 of our counter. National Forensic Science University, which works under the Ministry of Home Affairs. Please come to page 142 and see, my lord, 11, 12 and 13. These are the 3 records: IT returns, trade notices and Factory Act. Please see creation date 31st July 2020. That is the seizure date. And modified date, no modification. Since 31st July, we have not touched that record. Similarly, for 12, creation date 31st July, modified date 31st July. 13, creation date 28th July, modified date 20. So, we have not tampered because it's an unrelated record. We don't need this record at all. So, it is lost. My friend is saying, I can't take scan copy. You have lost means you have lost the case. You can't do the matter at all. I don't want, unless you give the original, I want to appear. This is the struggle we are now facing.
You can proceed with the show cause and the relied documents, that's all.
That's all. We will go and we give an undertaking. Please record it. Please record it, Lord. It's a constitutional court. Please record it from the respondent. We are not relying on these 3 records. Number 1. But as regards his prayer in page 19, Lord, please see his prayer. Just 1 minute on that. This is the only dispute which your lordship can do. He now asked time for filing reply, then allowing cross-examination, then appropriate orders for giving the word. So all this he has to now first go before the adjudicating authority. Have we denied him cross-examination? We have not done it. He says he applied, but he applies and doesn't come and take the records. How do we progress? So first step, let him collect all these records which are original and a scanned copy. Second, let him apply.
I have even written to them.
Today evening 4:30 we are ready.
We'll come and verify the originals and take everything.
4:30.
We have been writing the 2 years.
He is not writing. He's refusing to come. I have to say this. He's refusing to come.
Lordship will see. So just to answer that point, after your lordships pass the final order dismissing my challenge to show cause notice, immediately after the within 2 days I said, please depute a time and place and we come and collect all the documents.
He is refusing to collect because 11, 12, 13 is not available. Please see my recorded report.
There is a 3 case की scanned copy. बाकी सब 3 case जो disputed है क्यों नहीं मालूम? We are not entering into the dispute. Scanned copy है सर हमारे पास जो होगी आप दे दीजिए. Scanned copy
we are not relying on them. Please record it. We are not relying on this record.
You have only scanned copies of 3 cases. ठीक है. So the rest is clear हो गया सर. उसमें कोई वो ना 3 की हमारे पास scanned copy. So that is why.
And my lord, if possible, my lord, 7th writ petition, he has to stop somewhere.
We cannot prevent them from filing the writ petition.
He has to now start participating in the proceeding.
They will be visiting this court again and again. You said rightly.
So,
yes, next.
Please put an abusive cost if possible. Keep your blessing.
That's not because my audit side feels it's a Roman level 7 is a weak level number, so we should not file that petition. Now let's figure number 35.
Yeah. We have heard the matter.
Next matter.